General here by virtue of my office.
Thank you, Mr. Attorney.
Your Honor, I'm Olive Mugenda, Commissioner representing the public and also chairing these interviews. Welcome.
Thank you, Chair.
We also have Honorable Anne Amadi, who is the Chief Registrar of the Judiciary and Secretary to JSC.
Good morning, Judge.
Good morning, Your Honor.
Also, we have Frida Mukaya, who is the Registrar of JSC at the corner there.
Thank you, Your Honor.
So once again, welcome, Judge. A few housekeeping issues. Please be precise in your answers as much as you can so that we can manage time. And I'm also asking my fellow commissioners to also be precise in their questions and also keep within the timelines that we have decided. Your Honor, feel free to ask for clarification if you're not sure or if you didn't hear the question properly, so that you are able to answer the questions properly. After 2 hours, we are going to take a break, and Anne Amadi will come for you to take you where you're going to have your break. Or maybe you can even go to your office because it's around here.
Yes.
Okay, so you now start with the interviews. And I'll start, Your Honor, by asking a question. We have read your very impressive CV. You have done a lot of work for judiciary the last 30 years. And in 10 minutes, because the rest of the details will come through the questions, but in 10 minutes, please summarize why this commission should nominate you for the position of CJ.
Thank you, Chair. Thank you, Commissioners. I joined the judiciary 34 years ago in 1987 as a district magistrate, professional, that's what they were called those days. In those 34 years, I have risen through the ranks to become a judge of the Court of Appeal where I am today. 3 years ago, my colleagues in the Court of Appeal identified me to be their captain and unanimously elected me as their president. As I steer the Court of Appeal, I'm pleased to tell the commissioners here, that the court, despite the numbers which we are all aware of, has done a great job under my leadership. The court has been able to put in place case management systems that has seen it reduce the backlog in that court. When I took over, there were 7,000 or so appeals pending. 2 years later, they were down to 4,000. We had and finalized 3,000 through active case management. Unfortunately, the numbers kept dwindling. Unfortunately, COVID-19 came, and these numbers have started rising, heading back to 7,000, 8,000. The Court of Appeal, under my leadership, is regarded as one of those courts that are most collegiate, where judges work together. There's chemistry in the way we work. The Court of Appeal is also known for delivery of robust decisions. But all this has been because of my leadership, because when I took over, we identified as a court the gaps, one of which was the backlog at the time, the delays in judgments. We had judgments that had been pending from our court up to 3 years undelivered. We took a deliberate decision together that all those judgments, we sat in June of 2018, April 2018, and we agreed that by June 2018, we must have all those judgments delivered. So when we assembled in June again to review, we noted that we still had a few left. The judges had worked really, really hard to reduce the backlog of delayed judgments. So we extended time to August, and by August, all those judgments were delivered. As I speak to you today, Commissioners, there is no delayed judgment in that court. Perhaps 1 or 2, 5 months or 6 months, again through leadership of myself. How did I get to the Court of Appeal? And I want just to add that when I was elected by my colleagues, I was not the senior most. In a list of 20, I was number 13 in terms of seniority. In terms of age, perhaps the same number. And so they saw something in me that they identified with, that they thought would make a difference in the court, hence the unanimous decision to pick me as their leader. And I want to trace my journey to the Court of Appeal from the time I joined in 1987 as a district magistrate. As a district magistrate, again, I was identified, having worked only for 1 year, working in this very building as a district magistrate and dealing mainly with criminal cases. The chief magistrate at the time, Mr. Justice Mango, identified me to head the traffic court. And he told me in particular that that court had had problems of integrity. Each time a magistrate was posted there, it became a toll station. And he said, I want you to streamline it. He made me in charge of that court. He asked me to ensure that more traffic courts are established in Nairobi and its environs, and I did that. 1 year later, while still a district magistrate, I was promoted my second year in the judiciary to the position of resident magistrate. Hardly had I done a case than I was called by a team of JSC members, just 2 of them, Mr. Justice Nyarangi, who was then in the Court of Appeal representing that court to the Commission, and Lady Justice Joyce Alwach, who was representing the High Court. When I got a call that I was required to go before them, my reaction was panic, because I didn't know why I was required before the Commission members. With them was Mr. Justice Mwera, who was then the registrar of the High Court. That's how they were called, a misnomer, because the registrar of the High Court was really the chief registrar of the judiciary at the time. With them again was Mr. Jacob Olekipuri, who was then the deputy to Justice Mwera. And I was told that the two had their hands full as administrators. The more we were expanding, but the administration only had 2 people to help the Chief Justice, so they wanted a third hand. The truth of the matter was that Mr. Justice Mwera was being elevated to the High Court, and Mr. Jacob Olekipuri was taking over as the registrar. So they picked me as a deputy to Mr. Jacob Olekipuri as the deputy registrar. Working in administration, which I did for 17 years, exposed me to many things. While serving as chief court administrator, which was the highest at the time, actually had just been created, I was the first person to occupy that office, and 2 others did after me, or 3 others. I was exposed to many things in the court system. I made so many reform initiatives that we enjoy up to this day as a judiciary, and I just want to give a few examples. The medical scheme we are having today, it was my brainchild, and this is how it happened. I'll be very brief. As judges, magistrates, and other judicial officers and staff, we were being paid a medical allowance or up to the standard of your cadre. All put together under the printed budget came to something like 20 million. And then we had also a line called ex gratia medical, which came to about 30 million. I worked out these figures. We commissioned a healthcare provider, and I approached PS Treasury with these figures of 50 million, having consulted very widely among our colleagues, and I traded off. I said, take away the medical allowance that is in our salary, and take away the ex gratia vote, and we get a medical cover. And we started off with one officer alone, first year. The second year, an officer and a spouse. It has grown today to an officer, a spouse, and I think 4 children. Per diem that we today receive when we travel on official duties, again my brainchild, because of the demeaning manner people were surrendering impressed. You are given 10,000 to go to Kisumu on official duties. You only spend 3, but when you come, you have to account for 7. And you'd see all manner of receipts. It was quite demeaning even for judges. And if you didn't surrender, then of course next trip you would not go. Again, I negotiated this with the PS Treasury at the time, and they changed it to per diem that we enjoy today, so you don't have to account every a day is costed, and if you go for 10 days, you're paid equivalent. Apart from those two, in administration, I also took part in many reform initiatives. I was appointed a joint secretary to the Kotut Committee by the President of the Republic, the late Daniel Arap Moi. And Kotut Committee was formed to delink or to address issues of terms and conditions of service of the judiciary. The Kotut Committee made a report that completely delinked the judiciary from the mainstream civil service. The judiciary, for years, from independence, was an appendage of the Attorney General's chambers. All our staff, all secretaries, clerks, executive officers, all were seconded from the Public Service Commission to the judiciary. With the Kotut Committee and the report, this came to an end, and we adopted, so to speak, those who were seconded to us. Hence, that's the time we started using PLS 1, PLS up to I think 12 or 13, which have now been converted under your organization review. And that's how we delinked completely from the mainstream public service. The other thing we wanted to do after the Kotut, I was part of the implementation committee that was to implement this, was to completely identify our needs. And one of those needs was to try and have our own pension scheme, away from the one that is enjoyed by the civil servants. I will, if you ask me later, I'll be able to say more about this. I then was appointed as a secretary again to work in the famous Quach committee, again dealing with issues of judicial integrity. Again, after that, I was part of the implementation team that was implementing the recommendations. Finally, I worked, a meeting was called by the then Minister for Constitutional Affairs, the late Mutula Kilonzo, with the Chief Justice at the time, Honorable Mr. Justice Gisheru, and Emeritus Attorney General Amos Wako. Of the Court of Appeal judges at the time, a few High Court judges, and Law Society, and many players in the justice sector, the issue was reform. At the time, reform was in the air. This was after the Kriegler Commission and all that. In that meeting, again, I was perhaps the youngest and perhaps the most junior. I was asked to chair a task force that was appointed to look at the reforms in the judiciary. That task force was multi-sectoral. The current Speaker of National Assembly was a member. The Honorable Mr. Justice Lenaola of the Supreme Court was a member. Senator Okongo Mogeni was my vice. And I can go on, and it was multi-sectoral. Apart from myself and Mr. Justice Lenaola, most of the members were from outside. We did our work, and that work is reflected in Chapter 10 of today's Constitution. This commission, as constituted today, was recommended in that task force. And so many other things that are in that chapter came from the task force. So, Chair, I believe that with my qualification, that with my training in court administration, with all the things I've done to bring change to the judiciary, that I'm capable of moving this institution from where it is to another level. I thank you.
Thank you very much, Your Honor, for that explanation. My second question is regarding your time in judiciary as an insider, Your Honor, and you interacted closely with Emeritus Judge Mutuga and also Emeritus Judge Maraga, and both who came up with great initiatives, great blueprints. So my question is, what reasons do you think interfered or affected their ability to implement those blueprints to, fully? I'm asking that because there are still gaps. I mean, there's still ICT issues, there's still case management issues. So what affected, these great ideas not to be implemented fully?
Thank you. Correct observation. The two Chief Justices did great jobs. Chief Justice Mutunga laid a very firm foundation on issues of access to justice, built many courts, opened up the engagement, employment, and appointment of judges and staff. He did a great job in this institution. And Chief Justice Maraga picked from there and has also done great things. He has brought a sense of independence to all of us who work in the judiciary. But as you said, each one of them came with a blueprint, building on each other. And these blueprints, when you look at them, Mr. Justice Mutunga's blueprint, JTF, has 4 pillars, which are more or less replicated in the 6 pillars in Mr. Justice Maraga's SJT. Reform process is indeed a process. It is not a one-off thing. Even those jurisdictions that have developed, they have gone stage by stage. But I think really a critical look at the implementation of the reports, I do not see a focused approach. I think there's a bit of distraction because we are coming up with too many other things. If you look at the policy documents that we roll out, which are all meant to further these reforms, I think they take us off And I think we need to really focus on those recommendations that are aimed at enhancing access to justice. So I would say that we need to just focus and, of course, prioritize those that are hanging, low-hanging fruits, and those that are medium-term as well as long-term. Once we identify them, we should be able to see the movement clearly. But as it is now, there are many things happening around us, very useful things. Perhaps the coordination. Thank you, Chair.
Your Honor, you have talked of focus and coordination. Money was not an issue that we should maybe also address?
Thank you. Yes, money has always been a big issue ever since. Even when I was the accounting officer, money has been a big issue in the judiciary. Just to digress, up to 2003, just before I was appointed a judge of the High Court, the budget of the judiciary was 800 million. We had not reached $1 billion. Out of the 800 million, we were expected to raise in appropriations in aid 300 million. The Exchequer was therefore giving us only 500. This has really grown, really grown. It's to some of us who worked in the judiciary in the early days, this is really a dream come true, that now you can talk of 17 billion to the judiciary. But the judiciary has also grown in numbers and in activities, and so money is very critical in reform. Thank you.
Thank you, Your Honor. How would you describe your leadership style? Are you democratic, maybe too democratic? Are you authoritative? How would you describe yourself as a leader, Your Honor?
I am very democratic. And my colleagues in the court will tell you, no decision is taken from my office alone. Just to give you one example, everything we do in that court is done as a team. I'm just a leader. We looked at the number of applications pending in our court, 1,700 applications. Some were filed 4 years ago. Applications for stay, for injunction, simple applications. After I identified the problem as the team leader, I assembled the judges and staff, and I told them this is the problem. I knew what I wanted. I wanted us to clear this backlog of applications. And proposals came from the floor. We want to hear these applications. Can we list? Normally we list only 4 applications. I wanted to push them a little to list 6. It came from the floor that we list 15. Again, it was reviewed to 9. And we went out, and in 16 days, we had done 600 applications. And results are out there, rulings delivered. One thing, again, we agreed as a court is to borrow what the Supreme Court has adopted. The applications, you don't have to do 13, 15 pages. These are applications that are run of the mill. And so we agreed we would reduce the number of pages, and we were able to achieve. So through consultation, through teamwork, the court has been able to work together and gel very well.
Thank you, Judge. There are no times when you put that authoritarian hat at all?
Oh, yes. Sometimes you cannot, even as a democratic leader, there are times, a time comes when you have to insist that what you think is best for the team is what has to be done. And sometimes, yes, I do.
Thank you. My last question, Your Honor, is again checking your CV. I noticed that you are a member of the Judiciary Honors Committee since 2018. And one of the candidates that we have interviewed this week, Your Honor, said that there's no criteria, and if it is there, it's not well known, which determines or which, so that one is able to predict who qualifies for that award. So my question is, again, look at your CV, Your Honor. I realize that you got the Elder of the Burning Spear, EBS, in 2019, and also got the higher one, which is the Order of the Chief of the Burning Spear, in 2020. That is two very heavy honors in 2 years. So in 2 consecutive years, because there's nothing wrong with the honors, I think you deserve them. But then when they come in 2 consecutive years, my question is, much as you may be deserving your honor, was this due to your membership of that committee, or how did that happen? And number 2, could you have given a chance to one of your other colleagues in the judiciary who deserve to get this honor, so that you don't get 2 of them consecutive? And I'm saying this, Your Honor, knowing that you don't give the awards yourself. Your committee was recommending, but I'm just thinking that it looks a bit odd that, you know, you're honored 2 consecutive years. Maybe you can explain to us.
Thank you. Yes, Chair. I am a member of the Honors Committee that is chaired by the Honorable, the Chief Justice. We have only had 2 or 3 meetings. There's an Act of Parliament that deals with honors, and there's a criteria that is used to award honors. And we are just advisory as a Judiciary Honors Committee. We forward names which are received from different courts, different divisions, from different cadres to the National Honors Committee that I think is chaired by the Deputy President. It is there that they now choose who to give. And so it's not, we make a recommendation. Why I ended up with the 2? One, because it was realized that the honor that had been given earlier was lower than the level a judge ought to be given. So we made a case for the judges of the Court of Appeal, because they're the only ones who are getting that lower grade. So when we sent the names afresh to be given those honors, only myself and I think Mr. Justice Kiagi got the higher one. I don't know how they picked the 2 of us and left the rest. So it's not that I used perhaps my membership in the committee to do this. This is, it's quite, perhaps it's not very transparent also. We simply write to the courts, to the directorates, to nominate those they want to be awarded these honors. And from the list, we don't make any amendments, we send it as it is. Amendments are done in the National Committee. And we give everybody a chance. In my court, a secretary got, because she's outstanding in her work. Thank you.
So if you became CJ, is this an area that you would want to work on so that hardworking judges and judicial officers also get these honors? Is this something you would want to improve? Maybe come up with a criteria, maybe people can apply if they feel that given certain qualifications or achievements they deserve. Is it something that you might want to change?
Yes, because I don't know how each unit identifies those to be brought to the committee. We need to make it also very transparent from those units that everybody in the court, if it's magistracy, let all the magistrates know that this is happening this week, and we are nominating those we think have distinguished themselves. And so it is something that should be given as a reward for some achievement and not for any other consideration.
Okay, I think I'll add there, but just a disclaimer, Your Honor, that some of us have those two awards. My only problem was the consecutive years, so,
Yes.
but you have explained, and thank you very much.
Thank you.
I now request Acting CJI to continue with the questions.
Thank you. My Lord, just before we leave that point of the honors, you have described to us what you've done in your long service in the judiciary. Is it not true that the Chief Justice has in fact never chaired any of the honors committees, and that in effect you are actually the chair, my Lord?
I can't say that the Chief Justice has never chaired. The retired Chief Justice asked me towards the end of last year to chair on his behalf, and I've chaired 2 meetings. So I do not know. That was really my first interaction with the committee, so I can't tell whether there were earlier meetings.
No, I'm talking. This is important because not only did the judge raise it, you know there are mamas in the institution. You live here, don't you? So you know what our people have been saying about those honors. So I think it is a topic that we ought to make closure about, and this may be the opportunity.
I agree.
Emeritus Chief Justice Maraga, for the last 2, actually for the 4 years that he was here, he did not chair an honors committee meeting. He always delegated that to judges, and you are one of the judges to whom chairship was delegated in the last 2 years of his term. That's my concern, because I want to ask one other question on the issue. Is that correct?
Yes, as I said, I really do not know the circumstances under which the retired Chief Justice asked me to chair. I thought it was a temporary thing. I didn't know, because under the Act, he is the chair.
He is the chair under the Act. Let us confine ourselves to the period you were chair. He never chaired during your membership, did he?
No.
No, he did not. And therefore, that would be a serious place to start reform. You agree?
I do.
As Chief Justice, my Lord, you would be the Chief Judge and the Chief Administrator of the institution of the judiciary. Is that a correct statement?
True.
Let for now our concern remain with the Chief Administrator. You appear to have got to administration quite early in your days in the judiciary, correct?
Yeah, true.
As early as?
1989.
Since then, you've been, my Lord, in internal leadership of the institution of the judiciary. Now, being specific to yourself, forget the committees out there. Please tell us what your specific contribution has been to the benefit of the institution internally. I heard what my Lord said about the pension. I heard what my Lord said about the medical. But this institution is concerned with more than those two. My Lord would agree?
Yes.
So, as regards, and I heard what my Lord said about being president of the court for the last 3 years, and what the court as a team is doing under my Lord's leadership, correct?
Sure.
So now, my Lord, would you give us specific achievements under the 2 heads, administrative and judicial, for that period, my Lord?
I said I have served in administration for 17 years. And in administration, your duties are confined to the management of the court, staff, provision of tools of trade, facilitating the judges and staff. And as I said earlier, for administration, there is a lot that I did. I just mentioned two. I can also add pensions, as you've raised it. We started following the issue of pensions in the 90s, and there's one thing that has remained as a scar in my heart, that we've not been able to bring it to closure. But I'm pleased to say again that there's a lot that was achieved also. The magistrates and staff, magistrates and the other staff now have a separate scheme from the public service scheme. Is a contributory superannuation scheme, and that was as a result of my work in the committee that was looking at it. It is that committee that made a proposal to the Retirement Benefits Deputy President and Designated State Officers Act that introduced an amendment to include in that act, because it was taking so long to get the judges' pension running, to include the Chief Justice and the Deputy Chief Justice in that act. My contribution as a magistrate was really brief. I only rose up to RM, and when I became a High Court judge, I believe my decisions when I was fasted to Malindi, I made decisions regarding the purpose and objective of using assessors in criminal trials, and I made a very strong case that it was not useful if the courts were not going to use their opinions to arrive at a determination of a criminal trial. And I believe as a result of that, I saw more or less a few years later, the use of assessors in criminal trials were deleted from our statutes. A very useful thing, something, if you asked me, we can go back to, but make their opinion useful, rather than just have them there give an opinion that you can rubbish. I made decisions regarding when I was in the High Court, regarding the use of confession before magistrates, and I thought that to confess a crime before a magistrate who is presiding in a criminal case was to take a magistrate to be part of the investigating team. I thought personally that it was not in order to call a magistrate to go before another magistrate under a trial within a trial to say that I did not torture, I did not promise. I made a decision to that effect. In Nakuru, I made another decision that has gone all the way, my lady, to your court, Supreme Court. This is a wildlife-human conflict, where I made a decision that it is the role of KWS to ensure that wild animals remain where they belong, and that if they escape and harm human or interfere with human activity like agriculture, then KWS is responsible, a decision that was upheld. In the Court of Appeal, I've also made my contribution in the jurisprudence of that court, and I have shared with the commissioners some of my decisions, among very many others.
Thank you, my Lord. As Chief Administrator, my Lord will be required to ensure that there is full implementation to the greatest extent of the policies that guide the way